Good morning, everybody. Welcome to our monthly Coffee and Compliance. This one, we've got a great regulatory update with Bay Law Group. I'm really excited to have Gary Lux and Andrea Summits joining us. They're both partners with Bay Law Group, giving you a regulatory update of things manufacturers, industrial companies should really be paying attention to on the legal and regulatory side coming up as you think about strategies and planning. A couple of housekeeping items. If you've got questions, please submit them through the chat. We're hoping to have like 5 minutes at the end of Coffee and Compliance to address your questions with Andrea and Gary. If you don't get to stay through the whole webinar or want to share it or watch it again, we're going to be sending out Gary and Andrea's slides and also a recording of this webinar. For those of you that don't know us, for Map History, we're a software company that makes it really easy to do site compliance for environmental and safety, pulling together all your different data sources, whether it be air data, water data, inspections map, into a single platform to be able to analyze that data and make more intelligent environmental and safety decisions. With that, I'm going to turn it over to Gary and Andrea. Thank you both very, very much for being here today.
Thank you, Ryan. Good morning. Welcome and thanks for joining us. My name is Gary Lux. I'm a partner with Bay Law Group, and I'm joined by my colleague and friend and partner, Andrea Summits. And what we're going to cover for you is a very high-level look at the salient environmental federal and state legislative and regulatory developments that impact industry, looking at some trends and some details there as well. So I'm going to advance the slide. This is our team here at Bay Law Group. And my background brief. Can you hear me okay, Ryan?
Yeah, I can hear you fine. If you want to share your screen, I don't see it coming up.
That would help. Okay. Do you see this now?
Yeah, perfect. Thanks, Gary.
Great. I'm sorry about that. Yeah. So my background is I'm an environmental lawyer with 37 years of experience, focused on environmental compliance and assurance. And I serve on the California Lawyers Association's Environmental Legislation Committee, where we get front and center on legislative policy. And I just recently wrote an article that's available to you if you're interested, that goes deep on new California policy entitled the 2021 Environmental Legislative Recap, a Return to Normalcy, that just came out about a week ago. I'm going to cover just some high-level aspects of California and also some high-level developments at the federal level. Let me invite Andrea to introduce herself.
Thanks, Ryan, and thanks, Gary. I'm Andrea Summits. I'm also a partner at Bay Law Group, and I also have been practicing about 30 years in environmental and health and safety regulatory compliance, helping companies figure out what they need to do to comply with the myriad environmental and health and safety regulations that apply to their facility. Also helping clients build compliance, programs, training, reporting, and internal systems to ensure that all the dots and I's are dotted and T's are crossed for their compliance programs. So I'll leave it at that for now, and there's more information in the materials.
Thank you, Andrea. So where are we now? We're transitioning into a new administration. It's still getting underway, but there was a lot of rhetoric around the last Trump administration as to rolling back and scaling back regulatory programs and enforcement. And during that time frame, there were lots of promises of a shift from the federal policies, and the rhetoric did not, in fact, become nearly as much reality as was promised. Clearly, there were attempts to shift both in terms of policy and enforcement, and ultimately it did not come to pass for the most part. What remains is largely the framework that preceded the Trump administration, with some nuanced and temporary retreats that are already underway with a return to the framework in the Obama administration. So the main impact, of course, the reason for this, I should say, is that the NGOs and the bluer states pushed back hard with successful arguments, and the courts, for the most part, obliged. The casualty, one might say, was that the full-time equivalent EPA staff did drop, and those who remained are experiencing morale issues. Even though the budget each year was targeted for a 30% reduction, every year Congress came through and restored the budget to the business as usual level for the most part, but a lot of EPA staff left. There was a lot of attrition, early retirements, morale issues, and those morale issues are with the agency today. So the policies of the Biden administration reflect a lot of where the public is today. And looking at recent polls on environmental issues, in particular energy and especially climate, the Biden administration has aligned with where the policy, with the public sentiment is with their policies. We'll see where that stands in a moment, but essentially, one more word about the promises to roll back policy during the Trump administration. There were so many promises ranging from the CAFE standards and tailpipe emissions for cars to offshore drilling. And the vast majority of those promises, as I mentioned before, did not come to pass. And the New York Times put together a very comprehensive look at the attempts to shift the environmental regulatory framework. And that comprehensive review ultimately concluded that many of the changes that did happen were pretty much qualitatively around the edges. And again, thanks to, if you will, the NGOs in the blue states and the courts, they essentially held the line, and we're now back to where, or returning, if you will, to where the previous Obama administration stood. But now as we look forward to see where the Biden administration is going, even though it would be political malpractice for the Biden administration to use the term Green New Deal, if you look at the essence of the Green New Deal, which is nothing more than a blueprint, an aspirational vision of policies, the Biden administration is moving largely in alignment with that. And so if you see their agenda, it's very heavily focused on climate reduction, renewable energy, and all that goes with that with respect to energy efficient buildings and green infrastructure, and phasing out or working towards the phase out of fossil fuels and emphasizing resiliency with climate and promising some green jobs that will go with it. And this brief look juxtaposing the GND, the Green New Deal, against where the Biden policy is moving, there's a strong alignment. And again, they won't use those terms, but if you deconstruct and look at what's in the Green New Deal, a lot of it is being proposed by the administration, particularly with the EPA and the other agencies. And so when we look at their focus, it's designed to, from a policy standpoint, address environmental justice, which is a big mantra theme of the administration, and it is embedded in a lot of the policies and enforcement. As I mentioned before, the morale is a big issue. I have a colleague who was at EPA for years, and she just shared with me that she left because of the circumstances with the agency, and she's not alone. And so there'll be a big focus on trying to restore the morale within the agency at headquarters and at the regional offices. And so the Biden agenda, in addition to EJ, environmental justice, is focusing quite a bit on discrete policies focusing on reducing the carbon footprint of the country in alignment with the Paris Agreement years ago that was reestablished in Glasgow, Scotland recently. And so we're seeing, notwithstanding the Supreme Court's recent decision that Andrea will share more with you about, the administration's focusing on energy efficiency with respect to buildings, getting towards zero greenhouse gas emissions by 2050, eliminating fossil fuels mid-century, mid-decade, next decade, and green infrastructure, which we'll share a little bit more about, in particular focusing on the mobile sources and transportation sector. As they say, personnel is policy, and a lot of the players in this space have, a history of working in the field. And we have John Kerry and Gina McCarthy focusing internationally and domestically on climate policy. The new EPA administrator is Michael Regan, former Department of Environmental Quality head of North Carolina's state agency, and Jennifer Granholm, former governor, focusing on Department of Energy, which ties quite a bit into climate, and then Pete Buttigieg, who ran for president, focusing on the green infrastructure aspect of electric vehicle charging, among other aspects in the Department of Transportation. And then ultimately, two other players, Brenda Mallory in the Council on Environmental Quality that advises the president and focuses on the national environmental policy and other related topics, and then a former Congress member, first Native American, who was a former congressman leading the Department of Interior. So enforcement's a big part of the story, and it's no surprise that there's heightened and much more aggressive enforcement posture, both with the Department of Justice and the Environmental Protection Agency. The DOJ's focus, among other areas, but in particular, is on and corporate environmental crimes. And in particular, looking at those alleged corporate environmental crimes involving fraud, conspiracy, and covering up the crime with obstruction of justice. So those are areas of focus criminally in the Department of Justice. And civilly, there is a focus on those industry sectors from a civil standpoint where all or most of the sector is deemed to be out of compliance. And lastly, the Department of Justice is focusing on environmental justice. What went largely unnoticed at the end of the Obama administration is a dramatic increase in the potential penalties that could flow from violations of the major environmental statutes, from the Clean Air Act to the Clean Water Act to RCRA and others. The cost of living adjustment was established whereby the penalties increased either by 2 times or 3-fold in all those statutes. And if you see on the screen, these are penalties per day, per violation, which are dramatically higher. So it will drive the need to stay strongly in compliance. Another aspect of enforcement that's worth noting is that the Department of Justice and the EPA have entered into a memorandum of understanding to essentially require or incentivize the alleged defendants to identify misconduct at the highest level within the organization before they settle. And so this motivates the company to identify the individual or individuals who, through their actions or inactions, are potentially or responsible for the alleged wrongdoing, and bring them forward before they can settle. So that's a big incentive there. With that, let me see if I can turn it over to my colleague Andrea for federal developments in more detail.
Okay, thanks. Thanks, Gary. These are all the subject areas that we're going to cover in the federal developments. You can go ahead and switch to the next slide, please. So Gary's talked a lot about the focus of the Biden administration and the current EPA on climate change. what's happening right now is that although some measures have been able to get put through the infrastructure bill, which was successful, some energy and some of the transportation initiatives, what's happening right now is the reconciliation process. And just last week, Joe Manchin blocked some of the additional energy and EV tax credits that were intended to go through to help the administration's agenda on climate. So there's talk right now that Biden may need to actually declare a climate emergency in order to be able to make any further progress with the gridlock in Congress, so that he can take executive action without Congress having to be involved. So be watching for that. He's getting a lot of pressure to do that, and has put it on the table. So it may happen within the next week or so, or it may take a little longer. Meanwhile, he's also doing some things, EPA and Biden, shifting a focus from coal to natural gas. Natural gas is now the leading source of electricity, so that's becoming a higher priority. That coal was the focus of Obama, and now Biden's really starting to focus more on natural gas. It's also really focused on private partnerships, so partnerships with the private sector to reduce greenhouse gas emissions. Given the gridlock in Congress, that may be where he gets the most bang for his buck. So if you're in an industry that is in discussions with the administration to reach some voluntary agreements on reductions with EPA and with the administration, that may be something that touches you. The Supreme Court decision, I'll just touch on it briefly. Gary mentioned, you probably all heard. The bottom line of it is that it doesn't completely eviscerate EPA's ability to regulate climate change, greenhouse gas emissions at a facility level. But what the court's decision was based on the fact that they said EPA does not have authority under the Clean Air Act to force an entire shift from electricity generation from fossil fuels to renewable sources. That aspect of it went beyond their authority. So it will make big changes harder for the administration, but it hasn't completely eliminated their authority to regulate greenhouse gases. Under air quality, I just want to mention there are a number of things here to be looking at. NOx and ozone are going to continue to be a focus, and air quality in regions where there are disadvantaged populations often suffering the brunt of poor air quality. Methane and HFCs we're going to talk about a little bit more, but the Clean Air Act exemptions that you may have been taking advantage of in the past for startup and shutdown and malfunctions, when you have an exceedance of an emissions limitation under one of those types of circumstances, then there's been an exemption or a defense, if you will, from exceeding the limit. But that is getting across the board eliminated by EPA. So pay attention to that. If you're still in one of the few, they've been chipping away at it for years, but if you're still in a jurisdiction or a region where they allow that defense and that exemption, it's probably going to go away. Proposals are on the table. Next slide, please, Gary. With respect to water, you've probably watched over the years the definition of waters of the United States being kicked around and back and forth. This one also has been sort of a political football. The Obama administration put out one definition, Trump administration put out another. Supreme Court's been all over it and changing their complicated decisions related to this definition. What's happening right now is the court has decided to hear Sackett 2 in October and issue a final decision by next summer of 2023. So EPA has put off its plans to release a proposed rule on the definition of waters of the United States until November 2023, and then probably a final rule will be subsequent to that. Right now, what they're doing, this all impacts Clean Water Act permitting, this definition. So the EPA's current stance is we're going to go back to the pre-2015, the pre-Obama rule interpretations of the Supreme Court decisions for what constitutes waters of the United States, pending this decision and pending further input from stakeholders and so forth. So that's where that stands now. It's a confusing area of law because all courts are all split and different circuits are split on which test to use. So the infrastructure law we mentioned, that also provided a huge amount of money towards water systems to replace lead lines, to address emerging contaminants, including the PFAS category of chemicals, and make water systems more resilient to different kinds of threats. Okay, next slide, please. For PFAS, PFAS is a broad group of perfluoroalkyl and polyfluoroalkyl substances. There's hundreds of them. So when you see PFAS, that's hundreds and hundreds of different chemicals within that category. And they're often referred to as forever chemicals because they don't break down and they're found in virtually every human being in the United States blood today. So it's become a huge priority for EPA, and they're tackling it from every single statutory framework perspective. There's a proposal to designate two of them, the biggest two PFAS category chemicals that are often the first focus of these initiatives, to designate them as hazardous substances under CERCLA. So that could lead to cleanup actions, reporting requirements, if there will be a reportable quantity established for them, and you'll have to report those releases, and then potentially even reopening previously closed investigations. More will be added and more will be proposed as additional hazardous substances as well. EPCRA, many have been added to the TRA reporting, so that may already be impacting you, and more will continue to get added. For Clean Water Act, MPDES permitting is under direction to consider PFAS as well. So you could see BMPs come out and permit conditions relating to PFAS. Drinking water standards, there's a proposal coming for a national drinking water standard for PFOA and PFOS, and that will include maximum contaminant levels and goals. And right now there's a lot of study happening to determine whether the standards they've currently been discussing, which are 70 parts per trillion, should be reduced to, in the 5 to 10 parts per trillion range, or even in some cases for specific PFAS chemicals down to, I think California is looking at 0.07 parts per trillion for PFOA. Prop 65, you may have more warnings you need to think about, may need to be adding these substances into your HAZCOM program, so think about that. Next slide, please. The methane rule, this is something that impacts the oil and gas industry. So if you're not in that industry, this doesn't really impact you much yet. But if you're either a new source or an existing source in the oil and gas industry, this will likely touch you. It is expected to go through. It will be looking at things like leak monitoring, having to conduct surveys every 2 months to detect where there may be methane leaks in your pipes or equipment, and then looking at specific equipment like pneumatic controllers, pumps, compressors, and trying to tighten all that up. And then an elimination of flaring and venting. So this is intended to reduce methane by 95%, and that's a huge win for climate change emissions reductions. Next slide, please. HFCs, if you are a user, importer, producer, distributor, packager, you touch HFCs in any way, this may impact you. It's a new rule. It's no longer in proposal stage. It's actually an established program now with new rules coming out to fine-tune different elements of the program, but it establishes a whole allowance allocation system and trading program for HFCs that will phase down and phase out HFCs by 85% within the next 10 or so years. And the end goal of this will be to reduce global warming by 0.5 degrees Celsius, which is not insignificant. So if you're using that, you will start to have to participate in this program. It's kind of like an emissions credits trading program. Next slide, please. I'm going to try to go really fast. I know we're running low on time. This is a new program. If you have any Clean Water Act hazardous substances in threshold quantities, which is 10,000 times the reportable quantity at any one time, and you're within a certain distance of navigable waters, you will, under this proposal, if this goes through, you will have to prepare a facility response plan that will address the worst case discharge scenario for that substance. So similar to the plans that are already having to be prepared for worst case discharges of oil, if you're near navigable waters, this will add an additional planning and plan document that you have to implement and manage and train and so forth, and update periodically. And with OSHA, I'll just say that heat illness is going to be one of the main focus areas for OSHA going forward. As the climate warms, workplaces are warming, both indoor and outdoor, and a lot more employees are suffering from heat illness and heat stroke and so forth. So expect some inspections, especially if you have warehouse and distribution facilities. Those are coming under a lot more scrutiny. And a new rule, if it comes out, is likely to include things like mandated break times, employee acclimatization, and controls for temperature and humidity. I'm going to stop there on the OSHA, and you've got the rest of the material on the slide, and turn it back over to Gary to highlight a few other things in California.
Great, thanks, and Andrea. Yeah, as far as California is concerned, there's quite a bit to say, but I'm parsing it down to some salient highlights. As I mentioned earlier, the article is in the Environmental Law News, just came out with a lot more detail. We're just really scratching the surface. And why do we talk about California? Because it's a trendsetter. A lot of the laws and policies find their way into other states and at the federal level, and there's a rich history of that. So we need to pay attention to some of the highlights here. As Andrea mentioned, PFAS is sort of the chemical du jour with the big focus. 2 bills recently passed prohibiting the sale of juvenile products that contain PFAS and prohibiting the sale of food packaging that contain PFAS, and for manufacturers to use the least toxic alternative to replace the juvenile products and the food packaging. They also recently phased out the PFAS in firefighting foam. So this is a trend. We'll see more of it in other industry sectors. And speaking of industry sectors, from a climate change standpoint, cement manufacturing has a significant carbon footprint in any state, and it's a big part of California's carbon footprint. And Senate Bill 596 requires the State Air Resources Board to develop a strategy to reach carbon neutrality by 2045, and that greenhouse gas emissions associated with cement must be reduced by 40% by the end of this decade to help reach that statewide goal of neutrality by mid-century. Warehouse. Yes, sir.
Gary, we're running low on time, and I know California's got a lot of nuance to it. Maybe we can do a California-specific update, and we can send out your article to folks on the call to give them a little more detail, just because California is so nuanced with it.
That's fine. Yeah, I've much more to share if you'd like us to share California.
Yeah, we'll do a follow-up. We'd love to have you back, and let's do a California focus, because there's a lot I know in the transportation sector, the cement industry. I mean, California's got stuff for everybody on the environmental side. So we can dive
and there's
into
more
that.
information in these, and there's more information in these slides too for people to look at when you receive them from Ryan.
Yeah. I'll just say, like, just briefly, there's a lot on EV, a lot on climate, and air quality. So yeah, we can certainly cover that in more detail another time. Happy to do it.
Yeah,
Cool.
and SB 1383, which went into effect in January 1st. So if you haven't already put new trash and recycling and organics bins around your facility, you'll probably need to do that.
We are truly going to touch every industrial sector out there with the California regs: waste, recycling, cement, transportation. Yeah. No, thank you very much, Gary and Andrea. We'd love to have you back and do another one of these. I really appreciate the time today and giving everybody an update.
Our pleasure, truly.
Yeah, thank you, guys. Thank you all.
Thanks. Have a great day, everybody.